It is time to start the meeting. We've also formed a quorum. So I call to order our meeting today. Please invite the administration's representatives to join us. Thank you for coming, including the team from the administration. The name list is tabled, so I do intend to introduce the public officers one by one. We have already got the response from the administration to matters raised at the meeting held on the 4th of November. The paper has been sent to members. So you'll find it in paper CB bracket 2 307/14 to 15 bracket 02. I would like to give the floor to Mr. Chen, Deputy Director of Home Affairs, to give us a briefing, and then I'll open the floor to members if you have got questions to follow up. Mr. Chen, thank you, Mr. Chairman. Good morning, members. At the meeting held on the 4th of November, members have asked us to provide supplementary information regarding a series of issues. We have already provided the information to your secretariat. Just let me briefly walk you through the information. In relation to the profile buildings, which are currently managed by owners' corporations or other forms of owners' organizations, it has been set out in the paper. Well, for those self-managed buildings and with those covering more than 500 units, we have said that we will be providing targeted support schemes to help them. Say, for example, we assign a dedicated liaison officer, LO, to maintain close contacts with the OCs and owners of such buildings or estates. Secondly, the dedicated LO will give frequent telephone calls to the OCs and pay more regular building visits, at least quarterly visits, and take the initiative to ask for the permission to attend the OC or owners meetings. Thirdly, such OC members will be given priority to participate in our department's structured training programs for OC members and thematic workshops and or seminars so as to enhance their capabilities in building management. And our dedicated LOs will proactively invite them to join the programs, workshops, and seminars through appeal letters, phone calls, and personal contacts. Fourthly, for eligible OCs, we'll take the initiative to introduce to them advisory and financial assistance schemes launched by our department or other government departments or relevant bodies. Fifthly, through our LOs, we will provide neutral and impartial advice to OCs and owners on the pros and cons of engaging PMCs to manage their properties. And sixthly, if necessary, we'll refer the cases immediately to the relevant government departments, for example, Buildings Department, Fire Services Department, etc., for advice and necessary follow-up action. In addition to such new targeted support schemes, we would also have an alarm mechanism. That is, if OCs contemplate to opt for self-management, then we will take certain action. First of all, let me explain how it works. PMCs providing property management services are either deed of mutual covenant, DMC managers, or contract managers. Under the existing BMO, that is CAP 344, if you would like to terminate the appointment, a DMC manager or a contract manager, before termination of contract or non-renewal of the managers, the existing mechanism already permits the owners to vote on the matter after discussion and for raising their concerns. Our frontline LOs, through their daily contacts with the OCs and owners, if they have such consideration, if they have such inclination, then our LO will be on the alert, and if it does comes up, then they will immediately provide advice to the relevant owners, like telling them about the pros as well as the cons of engaging PMCs. And we'll also tell them that in the case of self-management, then they have to understand the legal and financial liabilities involving the OCs and owners themselves. Now, such a decision will have a serious impact on the owners. Even though there isn't a statutory requirement, we would strongly advise the owners to have the matter discussed and endorsed at a owners' meeting. For the rest of the paper, it also talks about what is meant by self-management of property by an OC and owners organization or individual owners. We've also got some information about cost content and detailed arrangement of CPD courses. I'll be happy to take questions from members. Members, any questions? Mr. Wu Chi-wai. 5 minutes each for Q&A as well. Mr. Chairman, yes, we have read the information about owners' organizations, but then I think owners' organizations cover more than OCs and mutual aid committees. So if there is an organization to take care of property management for a building other than an OC, an MAC, etc., I want to know what other owners' organizations can fall into this category. Thank you, Mr. Wu, for your question. I think Mr. Wu has already covered all sorts of owners' organizations that are known to us. I don't think there are other forms of organizations. Well, Mr. Chairman, in this case, in your interpretation, if I may go to Clause 2, where you have a definition for owners' organization, why don't you be more specific instead of being so general? This is how you define owners' organization. In relation to a property, means an organization that is authorized to act on behalf of all the owners of the property, whether or not formed under the building management ordinance or a deed of mutual covenant. In light of what you have said, I would suggest that you shouldn't define the term in this way, because that could very well be interpreted to mean that there is a fourth, a fifth type of owners' organization to act on behalf of the owners. I think it's a matter of legal drafting. Maybe my colleague can supplement. Mr. Lam. Well, the law doesn't stipulate how the owners' organization should be formed. It doesn't mandate that it should be formed under the BMO or a DMC. Perhaps it's up to members to consider whether you want to keep it flexible. The way that we have drafted means that we don't impose any restrictions on the organization. In other words, usually we consider two types of organizations, authorized organizations. According to your definition, some other types of organizations can be called owners' organization. So on what basis can they, say, for example, impose a management fee when they opt for self-management of property? As Mr. Lam has said, we'd like to maintain the flexibility. Of course, the ones that you referred to are those known to us, but we want to be flexible so that we can cover some other forms of organization as well. Can you elaborate on what you have got in mind? I think there is a conflict here. Now, for all new buildings, you have to draft your DMC in accordance with the guidelines of the Buildings Department. And then we have the BMO, which says that an owners' corporation should be set up, or an owners' committee under the DMC. Now, it seems to me that here you are sort of having a gray area. It may not necessarily give rise to controversies, but in light of what I have said, I just wondered if we should also dovetail what you have been promoting, that is to set up an OC, and also we should also look at the words of the DMC. And in fact, the BD's guidelines have already set certain parameters. So if you talk about flexibility here, I don't think there's actually any flexibility. However, by having it worded in this way, it may give rise to potential controversies. So basically, you talk about flexibility, but is it really flexible, or would the flexibility be too wide-ranging? I think members are concerned about self-management. Yes, we'll go back to consider it, but we do feel that it is necessary to keep a degree of flexibility. We'll consider the matter after the meeting. Any other members wishing to ask questions concerning the briefing given by the administration? Any questions? Well, on my part, for buildings or estates subject to self-management and covering more than 500 units. Just now, we've been told about the new targeted support scheme. Are you talking about newly introduced schemes? Do you have anything which is already in existence? At the last meeting, at previous meetings, the HAD is taking care of building management. We have adopted a three-pronged approach. First of all, we try to improve the BMO CAP 344, and we are currently having a consultation exercise. Next, we have introduced the Property Management Services Bill so as to enhance the quality of the service of the BMCs. And then under the HAB and HAD, we do provide support to owners, like setting up of OCs, their operation. We have also helped them in understanding financial matters, tendering exercises, and procurement procedures. We've been working on this all the time. Self-managed buildings and estates are also our clients.
Vice Chairman, thank you. I have another follow-up question. That is about self-managed buildings. Now, at these two meetings, we have been talking a lot about this. I remember the last meeting I put forward this opinion. That is, if we allow buildings to be engaged in self-management, there should be a decision-making procedure on a part of the building. In the reply, I don't see any answer concerning this area. We were just given a group of numbers. So if a resolution has to be passed by a building to decide that a BMC be removed, what do you think of that? In my briefing just now, I have already talked about this. For an OC, if it wants to change to self-management, what kind of procedures would there be? First of all, you would have to dismiss the DMC manager. Second, dismiss the contract manager. According to Cap 344, there are steps to be followed. You have to hold a general owners meeting. Now, if the DMC manager is to be terminated, it's more, the threshold is higher. You need 50% of the owners. Because this is a major decision, and it may lead to contractual responsibility problems. So an owners meeting has to be held. And as I mentioned just now, we also have an alarm mechanism in place. If our frontline staff, through their daily liaison, discovers this, because they always come into contact with the owners, and if they know that an OC is preparing to do that, the alarm mechanism will be triggered, and we will have special measures to support them, so that when the OC and owners make the decision, they would have thorough understanding of the situation they are facing. Now, this is a major and important decision for a building, so a general meeting would have to be held before such a change can be made. I have 2 points to ask about. Now, for the alarm mechanism, now it's already in existence. Your colleagues may give advice to the OCs from time to time, but it's not compulsory. The OCs can listen or not listen to the LO. If before the expiry of a contract, the contract manager is to be dismissed, of course there will be difficulties. But if the contract expires, then the OC can choose another PMC. It does not have to be authorized by the owners. It just have to follow the 20A requirements, unless the management fee is over $200,000. So by doing so, the OC does not have to convene a owners meeting to make the decision. If a building decides to opt for self-management, that is, there's no PMC, then I think there should be a owners meeting before such a decision can be made. Yes, what Mr. Wu says is right. Under the law, no passage of a resolution is required at a general meeting. Now, if there is a PMC managing a building and suddenly the OC decides that the service of the PMC will be terminated, then the owners would of course know, and they can use a 5% threshold to call for a general meeting. But you don't have to be so worried, because in the past 10 years there was only one such case, and we are talking about over 40,000 private buildings in Hong Kong. So there was just one case, that is an OC opted for self-management instead of PMC. As for single tenement buildings, over 500 units, last time it was 9 and now it's 6. That means some of the self-managed buildings have now chosen to have PMC. Well, many members are concerned about the loopholes caused by self-management. Mr. Allen Lau, 5 minutes. Chairman, you were right. We are afraid that the legislative intent of this bill may not be achieved if somebody used the loopholes. And some members have also pointed out that there are a number of loopholes concerning self-managed buildings. If you look at clauses 6 and 7 of the bill, one thing is very crucial. For a building, if its owner's organization decides to go for property management, then we would have to look at clause 2. That is, the definition of owner's organization in relation to a property means an organization or a deed of that is authorized to act on behalf of all the owners of the property, whether or as for the organization is whether or not formed under the BMO or a DMC. So I think you can stretch the imagination. There can be all sorts of organizations. Just now, what the Deputy Director pointed out was also right. Of course, people would like to engage a professional company to do the management, and if that is the case, it would be under the jurisdiction of this bill. That is the normal rule. However, there may be scenarios that we do not envisage now. For example, for some PMCs, they think this bill is too harsh. And then they talk to the owners' organizations so that they would opt for self-management. Then these buildings will not be covered by this bill, so we worry that this will become a loophole. So the definition of owners' organization is too broad. Shouldn't we tackle this issue carefully? Mr. Chan? As for the information we have in hand, we have 8,500 self-managed buildings in Hong Kong, and most of them are managed by OCs. Some of them are mutual aid committees, and a few of them are owners' organizations, but the number is very small. I can give you the detailed figures later. As for Mr. Leung's concern, at the advisory committee's stage, we have already had a detailed discussion. That is whether loopholes will be created. Our professionals in this area, as well as those who are familiar with this field, they think that there is not a big chance for these loopholes to be formed. Actually, they really want the licensing regime to be established as soon as possible so that their work can be recognized. And also they have to compete with their peers if they do not have a license in the future, even though they want to lobby the building owners, they may not be convincing. Owners would not accept these companies without a license and who are trying to make use of loopholes. So I don't think you should be too worried. Well, I just have 15 seconds left. I would like to ask a short question. Why doesn't the authority accept this? That is, there should be a threshold of 50% and a general meeting would have to be held, etc. Why don't you go down this path? Chairman, actually we are doing this. Now, if a DMC manager is to be dismissed, they need 50%. That is the threshold. And if a contract manager's contract has not expired yet, a general meeting would have to be held and the resolution has to be passed at that meeting. And just now our vice chairman has expressed his opinions. Would you also consider his points like flexibility and the definition being too broad? So I think we should foresee these possible loopholes and try to plug them as early as possible. I think at the past meetings we have repeatedly talked about this. And for the dismissal of PMCs, the vice chairman also mentioned that when a contract expires, if you want to hire a new one, because there are two thresholds now, that is 20% and $200,000, then this also causes members concern. Next, Mr. Chen Kimbo. Sorry, I am late. And I would like to ask some questions about this government's reply. Now we have sufficient information and we can make a decision. I asked whether a line can be drawn. That is, for an estate, if it has number of units exceeding a certain level, then a PMC must be engaged. Because now you're opening a loophole door. Now please look at page 3. The estate with the most units is 1716. Now that's about, if I draw the line at 1,800 units, then you would already have a gate. Now for buildings with over 1,800 units, they must engage a PMC. And if you have 1,800 units, I don't understand why the building can be allowed to manage its own building. And because you only rely on owners then, so I think you really need a professional PMC to do that. And I think what the number of 1,800 is an appropriate level. Now, I think amendments should be made so that estates with over 1,800 units must hire a PMC. Of course, I also support what Mr. Wu Chiwai said. Now, if you want to opt for self-management, you have to tell all the owners very clearly, and you need to pass the threshold. I have also helped to form OCs. I have experience in this area, and actually many owners are in the dark, and many of them just don't care. And they do not know what the consequence will be. Don't think the owners are so well informed as to whether they really are in the know. We have no idea. And if there are owners who have ulterior motive who make such a decision for them, then it may cause a very serious consequence. So during the consultation period, there were also objectors. This is something of a large scale. I think such an amendment should be made.
Mr. Chen, yes, 2 points to make. Time and again, we've said that the purpose of the bill and the licensing regime is to regulate the PMCs and the PMPs rather than the setting up of OCs, which is a matter for the legislation under CAP 344. Now, I understand that we are talking about a set of buildings with 3 blocks built in 1976 in Agongnam, Eastern District, with 22 stories. There were 2 major maintenance exercises, one in 1996, another in 2014. For such a large-scale development, it hasn't attracted any complaints for such major maintenance works. It's quite amazing. Well, I think if there is only one single complaint throughout, it means that it is very rare. So it is quite a good job for them to be able to manage themselves and have successfully completed 2 major maintenance and repair works. Well, of course, it is good to see that, but then it is the exceptional case. The majority of the buildings won't see this happening. Now, you have said that the bill isn't supposed to regulate the establishment of OCs. Now, you are giving an exemption. So I think there is a policy reason, and legally we are empowered to move an amendment. It is related. If not, then you would not have provided for the exemption. Now, you say that it is so good. So I think we should keep it and prevent other people from doing bad things. Next, Mr. Wu Chiwai, Deputy Chair, the 3rd round, 3 minutes. Mr. Chairman, I will quick. I think just now Mr. Chen has made it clear that for the worries and concerns that we have told him, it is unnecessary. Well, I don't know how it will be operated, but at least it appears from the text that you are sort of opening up some loopholes. Would like to impose certain restrictions. According to what Mr. Chen has said, I don't think we are preventing others from doing this. Now, Mr. Chen Kim-po is suggesting a threshold of 1,800 units, but then it will also give rise to a problem because it is not going to bind the existing buildings. It will only have an effect on new buildings. That is, if they want to switch over to self-management, there must be a resolution to be passed by the owners at a meeting. I think Mr. Chen also agreed that if the contract comes to its natural end, then I think there should be a tendering exercise to procure the service. But then there may be a sole tenderer only. So even with your bill, it doesn't mean that people won't try to make use of the loopholes. Now, it is very profitable and it is very tricky when it comes to property management. If you say that we are over-worried and the scenarios that we think of cannot materialize, then what about drawing a line at 1,800? What about requesting a resolution at an owners' meeting? Is it something bad? Unless the cons exceed the pros, I just cannot see why we can't limit it so as to prevent such a loophole from being abused. Thank you, Mr. Wu, for your point. Yes, I understand your point, and in fact, for a building to switch over to self-management instead of being managed by PMC, well, there are certain requirements. One being that the contract manager has finished with the contract is not renewed, and indeed, according to the existing legislation, unless the budget unless it exceeds 20% of the budget or it exceeds $200,000, otherwise they don't have to resort to tendering. I don't think it will be unknown to the owners, and in fact they can ask for a general meeting to be called once they can get 5% of the shares. I think that can be studied within the review of Cap 344, which regulates the acts of the OCs. Maybe in that context, we can add a requirement to say that for owners corporations who would like to opt for self-management, they should go through a particular process. I think the two pieces of legislation should be coordinated. I think members have already made their point. I think members have repeated their arguments, including what the Deputy Chair has said. So please consider their arguments. For the time being, I think members are still unconvinced by your reply. They still have a lot of reservation. Well, we haven't got anybody wishing to ask questions for the first round. Second round, Mr. Chen Tin-po. 5 minutes for Q&A. Thank you, Mr. Chairman. We are told that perhaps we should try to ward this off within the context of the review of the building management ordinance. I read your consultation paper. I'm most disappointed. You don't impose any criminal liability. You just talk about guidelines. In other words, they have no consequence at all, even if they don't abide by your rules. You ask for owners, you ask for general meetings to be held, but even if they don't call a meeting, they don't attract a criminal liability. So once again, you're not going to impose a criminal liability. I'm really disappointed. Wu Chi-wai has just left. So without a criminal liability, what can we do? Can it be effective? And my second question is, now, PMCs vis-a-vis self-management, the difference is huge. So even if they currently have a PMC, they would be tempted to switch over to self-management, so they can resign on their own initiative and then they opt for self-management. Don't be so naive. Once there's a loophole, then they will abuse the loophole. So many people are worried. So many people are telling you from their experience. Do you know about the large number of problems and complaints received by the FTU, the DAB, etc.? Now, even when you amend the BMO, you are not going to be effective. I really hope that it is effective, and I don't think we should check from this, otherwise it would be a direction of my duty as a legislator. Building management is a very difficult issue. It is not that easy to do it well. We would like to improve Cap 344. We want to introduce appropriate measures. Just now you talked about self-management. During the consultation period, we visited all the 18 district councils. We understand that self-management should not be covered by this licensing regime. I think the message is loud and clear. If I may also remind you of this point, as to the number of units referred to, I don't think you're going to affect the existing buildings, not at all. As to the point made by Wu, that is, perhaps you should impose certain thresholds for conversion into self-management. I think the general feeling is that it is too lax and it may give rise to many loopholes. If I may sort of give you more time, as I am using your time, Mr. Chen. Now, the BMO is not going to impose a criminal liability. So what's the point of amending the law? Yes, within Cap 344, if you provide false information, etc., you'll be criminally liable. I hope you understand that for the operation of owners, corporations, and the members of the MCs, they do it on a voluntary basis. They don't receive anything in return. They just serve the other owners, and the office bearers have been elected by their peers. If we enhance the criminal liabilities, then we are afraid that this will be discouraging the owners. I don't always want to interrupt the public officers, but he's repeating himself. I don't think it is going to work. Now, you say that the government would like to impose 10 requirements, but non-compliance won't attract any consequence. So what's the purpose of amending the law? Now, I think what you have been talking about would only be applicable to a single tenement building or a group of 2 blocks. But then we are more interested in large estates with over 1,000 units. Now, in the past, it was most outrageous. It was said that proxies should only be put up during the time when the meeting was held. Now you say that they should be posted for 7 days, 14 days. Now you ask for that to be done, but then you can choose to do it or not. No one would follow your requirements if you don't impose a criminal liability. The mindset isn't right. We are now having a public consultation exercise on Cap 344, and it will end in February next year. Mr. Wu Chi-wai, Deputy Chair, 4th round, 3 minutes still. Thank you, Mr. Chairman. I don't want to be repetitive, but still want to make 2 points. First of all, we don't intend to regulate self-managed buildings. I hope you are clear about this point. We just want to make sure that such a matter should be regarded as a major decision to be endorsed by resolution, so the owners are aware of it. Now, my second point is, now we ask for general meeting to be held to enable owners to decide on certain things by resolution. We want this to be included. What harm would it do? Is it going to cause any damage to owners or the PMCs? If there is, then of course we should reconsider the case. If not, then clearly it is a matter of even if someone would like to abuse the loophole, they still have to overcome the hurdle of an owners' general meeting. Mr. Chairman, well, this is to regulate the PMPs. If we are to regulate the OCs and their conduct, we shouldn't work through this bill. It should be via the channel of Cap 344. We are now reviewing Cap 344. If we would like to amend the law, amend the subsidiary legislation, or if we want to introduce some bylaws and codes, that can be done, but not under this bill, not within the context of this bill. Mr. Chairman, I've made my point many times. We don't intend to regulate the buildings. We don't want to regulate self-managed buildings. But then I'm just asking for a resolution to be passed if they would like to switch back to self-management or switch over to self-management. I don't intend to regulate the owners' corporations or the owners. Don't put words into my mouth.
We believe that this bill is to regulate PMCs. As for OC's decisions, is governed by BMO. So this is what a present system is like. Well, we have different pieces of legislation, and there can be a back-to-back arrangement. Here, in the course of making the decision, I'm just suggesting that a resolution must be passed by owners at a general meeting. Why is it not good? I think if you put it under the existing bill, nobody would object to that. If you do not have this exemption arrangement, then there would be no problem. So I'm just now targeting the exemption arrangement because we want to plug this possible loophole. So the government, please pay attention to this. Now, if there's no exemption, then it won't cause any concern. I think the exemption has aroused members' worries. Why aren't there conditions attached so that the possible loophole can be plugged? Chairman, we can go back and think about it. Maybe this can be resolved by Cap 344. Chairman, I am sorry. That means he doesn't want to do it for the present bill. If that is the case, we will move CSA ourselves. So would the government consider this seriously? Otherwise, our members may move their own CSAs. Members, concerning the government's reply, do you have any other questions? If not, I suggest that we resume our clause-by-clause examination, which was started at the last meeting. Members, please refer to the blue bill, CB bracket 3583. And I would like to remind members that we were on clause 2 last time, interpretation. We just talked about the definition of property. That's page 2731. Property. Will the government take us through the bill clause by clause? And then members can ask questions. I suggest that Ms. Leung explains the clauses. If it's about drafting, Mr. Lam would answer the question. If it's about policy, I will answer the questions. Thank you, Chairman. With regard to clause 2, I have chosen some more important terms for explanation, for example, property. And later on, I liaised with the Secretariat. And this time around, I will explain the terms one by one in order. So that is after my communication with the Secretariat, we have come to such a decision. Well, for the definition of property, at the last meeting, we've discussed about it. And at the meeting, members asked about whether standalone houses will be covered. And the government's reply is in paper 1761 bracket 03. Well, that depends on whether there are communal areas in the development. For example, Zhenfei Fayuan and Poutou Yun, this bill will be applicable to them. And let me go back to clause 2. Or do you want to discuss more about property, or should I start with appeal tribunal? So for property, because we were all very concerned about it, if you have supplementary information to provide, and we can continue to talk about this. For the term property, as the legal advisor pointed out just now, when it comes to an estate of stand-alone houses, we will have to look at the actual situation. If it's a development with DMCs, then it will be covered by this bill. If members have no other questions, then Ms. Lam, please go on. I will explain the terms in order. First, appeal tribunal. Its interpretation. It is defined like this, that it means an appeal tribunal appointed under Section 34. As for its formation, composition, and operation is in Part 6. When members scrutinize Part 6, we can look at the composition and operation of the appeal tribunal in details. Okay. Next, company. Company has the meaning given by Section 2(1) of the Companies Ordinance and includes a body corporate, incorporated or otherwise established by or under any other ordinance, or incorporated or otherwise established outside Hong Kong. Please continue. Legal advisor. A drafting problem. In the Chinese version, concerning the wording A and B, 成立或設立. But in English, it's incorporated or otherwise established. I have written to ask the government, because the word otherwise does not appear in the Chinese version. So for incorporate, it's 成立, established is 設立. The word otherwise is not translated. The government says that the word otherwise will be deleted. Ms. Lau? Yes, we will consider moving this amendment. For the interpretation of company, between A and B, the Chinese version, you use the word cup. For A and B, I think it's either A or B. That will be all right. Do you mean that you have to have both A and B? Well, for Chinese it's cup, and for English it's or. Well, could the government try to align that? So the concept should be or. Well, for the way of expression, it's different in the Chinese version, in the Chinese version and the English versions. Because, well, for A and B, we are talking about different body corporates. But so for the body corporate in the Chinese version, is put under both A and B. But for the English version, the body corporate is not under A or B. So there are different ways of expression. So that's why A and B would not be connected with an and. Well, as far as I understand, well, I'm reading the Chinese version. These are two different types of organizations. So if you use cup, you mean that you have to meet the requirements of both A and B before you can be regarded as a company. No, we are talking about two different types of body corporates. So does cup means or? It includes both A and B. Well, in the Chinese version, you should not use cup. You should use wak or. Well, because it has the characters being 包括 and includes. Well, if you are giving a definition to a word, it includes if it includes 10 things, then you can use the conjunction and. You do not have to meet all the 10 conditions before you can be defined as that. we don't think cup should be changed to wak, because that would mean either A or B. Can it be the two things at the same time? You have used the Chinese characters being bao and then you use cup afterwards. In the Chinese semantics, is not correct, because you need to meet the criteria of both A and B before you can be defined as a company. But if you use wak, then it would means it's either A or B. Then it cannot cover all the scenarios. Mr. Ho? I think the problem lies with the word bao includes. As far as I understand, it's either or, but if you use include and then you use or, it seems that is inconsistent. So to dispel our doubt, can you go back and dig up some examples of using cup? And if we can see past examples, then we would be more reassured. If it doesn't use the word bao include, then a company can be A or B. Then you can use or. So I think the problem lies with the word bao. Yes, we will write a paper telling members when we will use and when we will use or. So it means both A and B are acceptable. In English, you use includes and then A or B. If you translate it this way, of course, we would be confused. Now, if body corporates can be put under A and B, and then A and B are connected with and, maybe that's more acceptable. So, Mr. Lam, can you go back and dig up some past examples? So, we'll stop here and we will move on to another term. The next one is deed of mutual covenant. Deed of mutual covenant has the meaning given by Section 2 of the Building Management Ordinance. As for Section 2 of the BMO, the DMC is a document, and it defines the responsibilities, duties, rights, liabilities of owners, and it has to be registered with the land registrar. The next one is chairperson. Chairperson means the chairperson of the authority appointed under Section 2 of Schedule 3. As for the formation of the authority, the details are set out in Schedule 3. So when members scrutinize Schedule 3, we can discuss the composition and operation of the authority in detail. Members, and when Ms. Leung explains, if you want to ask questions, just raise your hands. Otherwise, Ms. Leung will go on if there are no questions. Thank you. The next term is member. Member in relation to the authority means a member of the authority appointed under Section 2 of Schedule 3. Next, Chief Executive Officer means the Chief Executive Officer of the authority appointed under Section 7(1)(a) of Schedule 3. Next, Secretary means the Secretary for Home Affairs.
委員會
Committee. In relation to the authority means a committee of the authority established under Section 23(1) or 2 of Schedule 3. Next, property. I think it was discussed at the last meeting and a moment ago, so I'm not going to repeat this point. Next one, property management practitioner means an individual who assumes a managerial or supervisory role in a property management company in relation to property management services provided by the company. For the property management practitioner, I've noted that many bodies have queried as to what is meant by assuming a managerial or supervisory role. I don't think it's being defined in the bill. That means we have to take the meaning, take the superficial meaning. But in light of the concerns of the deputations, perhaps the administration would want to study as to whether there is a need to explain this term. Mr. Chen. Yes, we did explain in great details as to what is meant by a managerial or supervisory role. During the consultation exercise in the subsidiary legislation, we will explain more clearly what is meant by assuming a managerial or supervisory role. So that will be taken care of under the subsidiary legislation. Deputy Chair, I think we have talked a lot about the content of the subsidiary legislation. If we have already got a concern now, would it be too late if we are made to wait until the making of the subsidiary legislation? So, Mr. Chen, for items that would be provided for in the subsidiary legislation, please also give us a general idea at this stage so that we are assured that the principal legislation and the subsidiary legislation are coordinated. Yes, I also agree that this is important. You talk about a person assuming a managerial or supervisory role. Your answer was that there will be more details in the subsidiary legislation. Now, members want to know if you can, at this stage, share with us what you have in mind. Yes, we do have some initial ideas. Maybe Ms. Leung can elaborate. Yes, if I may give you some supplementary information. Now, for the time being, what we are saying is that when the PMC is to apply to the authority for a license, then we assume that the authority would ask the company to, say, for example, tell the authority about the scale of the building under their management, like the floor area, etc., so as to find out how many PMPs holding a Tier 1 or Tier 2 licenses would be required. If I may clarify this point, you're talking about their previous record. No, at the time of application for license, like the properties under their management and the floor space. So they can't get it if it is a newly set up company. Well, for newly set up company, maybe the applicant should guess how many individuals have to be employed, and then the authority would make a judgment. That is, for the scale of business involved, then they would try to stipulate the number of managerial staff members to be required. Well, they need a certain number of Tier 1 and Tier 2 licensees. At the same time, we hope that the future authority would also look at the organization structure, and they should also look at the posts requiring Tier 1 licensees and Tier 2 licensees. So the authority will consider which posts would require a license and which doesn't. So the licensing conditions will cover that as well. I want to know whether there should be some objective criteria. Can the Bureau disclose this at this moment? Well, this is like the administration having to come to the ESC to explain the duties involved if we would like to create a post and ask you for the permission and to get the money. Mr. Wu, well, having heard his reply, now for PMCs under the Housing Department, usually the Housing Department would look at the number of units being managed, and then the HD will try to find out whether the company has got the correct manpower level to take up the management of more units. Say, for example, if a PMC has only got one individual holding a Tier 1 license, perhaps you have some basic ideas about the maximum number of units that a PMP Tier 1 license holder can manage. Of course, it is a very complicated licensing regime according to what you have told us, because we'll be interested to find out how many employees they need before they can provide quality property management service. So the basis for granting a license and also the conditions necessary, I think we'll be interested to know about such information now. If you ask us to wait until subsidiary legislation is introduced, I'm afraid that by then the principal ordinance would have already been enacted, and then there will be a gap, and then if we have a lot of disagreements, then it will be difficult to resolve. Mr. Chen. Yes, we'll try our best to present our suggestions to you. Once we have got the ideas, we will present them to you so that when you consider the bill, you will already know about our ideas for the subsidiary legislation. But then we are already at the stage of cross-by-cross scrutiny. It will soon be completed. Well, this is the interpretation part. Maybe when we are at the provisions covering Tier 1 and Tier 2 licenses, then we'll give you a more detailed account. So they're saying that at a certain point in our deliberation, they will come back to us on this point. All right, Mr. Chairman, maybe we have to hold public hearings concerning the criteria for granting licenses. Yes, when we are at that stage, we'll reconsider the matter. That is, if you think that there is a need for such an exercise, say, for example, if we have a number of issues that we want to invite views from the industry, then we will discuss this suggestion again. Sit Ho, I think it's necessary. Of course, we are in favor of enhancing the standards of property management service, and that owners should know which PMC to engage in the light of the scale of their housing development, etc. We understand that there is a grandfathering provision in other licensing regimes. Now you want to enhance the service, and you have asked for training to be taken by the PMPs. Just like in the case of the construction workers, we've always asked the question, that is whether you have the capacity to deliver the programs. Now we are talking about the career of many practitioners in the industry. We have to be careful. Yes, your concerns are noted. There are many details in relation to this bill that should be provided by the administration. I think there is a lot of concern in relation to the PMP. Don't just consider it. You should really work on it. Now, the employer would look at the matter from its own perspective. The occupants have also their own areas of concern, but employees would also be interested. So maybe for the PMPs, they need to enhance themselves, they need to be licensed, will be interested in the details. And of course, we want to find out whether there is a transition. Yes, I think your point is noted. Are we going to have a public hearing? We've just started with the definitions of the terms. You've made your point and it has been noted. So you still haven't promised. So can you simply say that there will be one? Mr. Yip Kok Him, if we say with certainty that we must have one, I'm not sure. But then in the course of our discussion, if there are areas for clarification, then we can make the arrangements in due course. Different stakeholders, of course, have got different concerns to voice. We can't simply call a public hearing when we want to know more. I think we need to do our homework. It is only when there is a need for it, then we do it. So I agree that we can sort of defer it for a while. And then if the practitioners have very strong views in a particular area, when we are clearer about the issue, then it will be meaningful and more targeted when we hold a public hearing. Then PMP Tier 1 license means a PMP Tier 1 license issued under Section H1B, Part 3 of the bill will set out the details concerning the licenses for PMPs. So maybe we can have the details when we are at Part 3. Next one, PMP Tier 2 license means a PMP Tier 2 license issued under Section H1C. Next one, PMC means a business entity, whether a company, partnership, or sole proprietorship that carries on the business of providing property management services. Thank you, Mr. Chairman. It talks about a business entity that carries on the business of providing property management services. The word business is included. What about non-profit making charitable organizations? I did raise this question. The administration has replied saying that that would also be covered. Maybe the admin can explain. For our interpretation part, we have no intention to carve out the non-profitable or non-profit making organizations or charitable organizations, because for such organizations to provide property management services to a third party, we are still interested in maintaining the service standards. Sit-hold. Does it mean that in future, since the MTRCL has been managing some large-scale property, large-scale residential developments, so it's the case of the housing society, will they be covered as well? Yes. So as we move on, we have to check. Now, I understand that the MTRCL has got its own ordinance. Let's check whether there are any conflicts between the two. Maybe our legal advisor can also assist. Yes, please watch out for any inconsistencies. Next one, PMC license means a PMC license issued under Section H1A. Next one, property management service means any service prescribed by regulation made under Section 3(1). For property management service, you'll find it in Section 3(1) and also Schedule 1 in relation to the detailed definition. So perhaps we can take it up in greater details under Section 3(1) and Schedule 1.
當然咧就係
If you've paid attention in the past, different stakeholders have different views concerning the 7 areas concerned. So later on we will look at the details. Next, licensee. Licensee means the holder of a license. Licensed PMP means there are 2 types. A licensed PMP Tier 1, or B, a licensed PMP Tier 2. And then is licensed PMP Tier 1. It means the holder of a PMP Tier 1 license. And licensed PMP Tier 2 means the holder of a PMP Tier 2 license. As for Tier 1 and Tier 2, I remember organizations and individuals have given their views to us. They want to know more about the differences between Tier 1 and Tier 2. Maybe the authority or the administration can give us more information concerning this in the future. Legal advisor? For licensed PMP Tier 1 and Tier 2, well, their definitions are very simple. It just means the holder of a PMP Tier 1 or Tier 2 license. But if you look at Clause 6, there is a registered professional property manager is Tier 1. And then for Tier 2, it's also called a licensed property management officer. And these 2 terms just appear here. So do you have to link them up with the definition of PMP Tier 1 and Tier 2? Mr. Lam, as for Clause 2, subclauses 2 and 3, these 2 terms are mentioned. First is Tier 1, registered professional property manager, and Tier 2, licensed property management officer. Well, for a licensee, as to how he calls himself. Now, first of all, if he does not have a license, he cannot say that he's a licensed PMP, either Tier 1 or Tier 2. And these are the descriptions that we have concluded after consultations. As for PMP Tier 1, in the law, it means the holder of the relevant qualifications under the law. But in real life, they may want to describe themselves as such managers, and they must be qualified if they want to call themselves such managers. As for the details concerning the license content, we will set them out in the subsidiary legislation, or when the authority comes into operation, there will be guidelines. So at the moment, we don't have details concerning the licenses. So on the license, the word PMP Tier 1 may not be used. There may be other wordings. But anyway, there is a difference between the 2 tiers. Well, for a PMC, it also has to hold a license, and it has to meet certain criteria before it can get a license. And one condition is that it has to hire licensed PMPs, and licensed PMPs are divided into Tier 1 and Tier 2. So who can get Tier 1 or Tier 2 license? This is very important because it will have a direct impact on the issue of license to the PMC. So for a licensed PMP, whether he belongs to Tier 1 or Tier 2, what kind of criteria does he have to meet before he can get a Tier 1 or Tier 2 license? I think this is a very important part of the whole bill, because this is a two-tier licensing regime. Well, and the bill is very simple. Well, as long as you get Tier 1 and you are PMP Tier 1. But for the practitioners, they would have to know what is meant by Tier 1, what requirements there are. Well, in particular, under Clause 6, there are descriptions of the PMP. For example, if you are a Tier 1, then you are a manager, and for Tier 2, you are an officer. So for a practitioner, I think he will be very concerned as to which license he can get. So maybe the administration can give us more detailed explanation concerning this in the future. And so if we have the details, the industry may be satisfied or not satisfied with such details, and then we can talk more then. And for Clause 15, the authority can stipulate rules concerning a license Tier 1 and Tier 2. There are different requirements. It's under 15(2). There are criteria set out. For a PMP Tier 1 license or PMP Tier 2 license, there would be criteria, and this criteria may relate to the person's academic qualifications, professional qualifications, and relevant work experience. As for Tier 1, the requirements will be more stringent. When members scrutinize this subclause, we can go into more details. The next one is license PMC. Means the holder of a PMC license. Disciplinary committee means the standing committee established under Section 23(1) of Schedule 3. As for the setting up of a disciplinary committee under the authority, the details are set out in Schedule 3. So when we reach Schedule 3, we can scrutinize in greater details. Next, Vice Chairman. Means the Vice Chairperson of the authority appointed under Section 2 of Schedule 3. Next, license. License means A PMC license. B, a PMP Tier 1 license. Or C, a PMP Tier 2 license. The next term is owner. Owner has the meaning given by Section 2 of the Building Management Ordinance. As for the BMO, Section 2, a owner is, according to the record of the Land Registry, it is shown that the owner owns a share of the land as stipulated in the relevant documents. Next, owners' organization. Just now we also discussed this. Here it says owners' organization in relation to a property means an organization, whether or not formed under the building management ordinance or a deed of mutual covenant, that is authorized to act on behalf of all the owners of the property. There was a discussion about this just now. Will the administration go back and amend its definition? Because this is a very important term. In particular, when we talk about self-management and exemption, we use this term a lot. That is owners' organization. So I think the use of this term has to be clarified. The way you draft it now is it means an organization whether or not formed under the BMO or a DMC. So all these would be regarded as an owners' organization. So if it's not established under the BMO or DMC, then it does not have the authority to decide on the operation of the building's affairs. So I think you should state clearly that the owner's organization must be set up in accordance with Cap 344. Other organizations should not be allowed to carry out such duties because it cannot represent the owners of the building. Well, just now you talk about flexibility. So can we hear more from you? Well, just now we said that we want to maintain flexibility. That's why we drafted this way. But we have heard Mr. Wu Chi-wai, and we will go back and think more about this, whether this definition is most appropriate. Let me talk about MTLCL. Well, there are some MTLCL managed estates which do not have OCs. They have tried to form OCs, but the owners really trust the MTLCL and they don't want to set up an OC. So under such circumstances, would there be an owners organization in such estates? In an estate, as to whether there is an owners organization, we will have to look at the actual situation. Well, have they formed an OC in accordance with Cap 344, or is a mutual aid organization, or is an owners committee? We really have to look at the actual situation. Now, for the MTLCL managed buildings, the MTLCL would have to get a license from us. Now, if there is no OC, well, actually, I would have to check the latest situation. That is whether they have mutual aid organization or not, or other forms of organizations. And if the owners have to go to the land registry and invite other owners to a meeting, then there would be a lot of troubles. So for the owners, if they do not have an organization, do they have a right under the law? Well, for owners' organization, actually, they are related to self-managed buildings. If there is no organization, they cannot manage the building and is not covered by this bill. So that's another issue. That is how the building is managed. Yes, I think I would need to check the latest situation because that estate is managed by the MTLCL. Of course, Well, if it's MTLCL, the quality is assured. But how about the shares, fees, whether they are calculated on a fair basis? I think the owners are very concerned, so I will have to check the latest status. Next, disciplinary offense. Disciplinary offense means the standing of disciplinary offense. As for its details, it can be seen in Section 4.
Authority. Authority means the Property Management Services Authority established by Section 40. Former Companies Ordinance. It has the meaning given by Section 2.1 of the Companies Ordinance, Cap 622. We have to define what is meant by the former Companies Ordinance. This is because in Clause 13, bracket 2, bracket B, if the PMC is incorporated under the Companies Ordinance or a former Companies Ordinance, the date of the incorporation of the PMC, some companies were set up or were incorporated under the former Companies Ordinance. So we do have this reference to the former Companies Ordinance. All right. Thank you, Mr. Chairman. I am going to raise a point, but it doesn't have to be dealt with here. It's related to Section 16. That is, certain information has to be provided by the PMC to clients, but then the word clients is not being defined here. Owners only? And what about tenants? That's the view of many deputations. So perhaps under Clause 16, the administration may want to define what is meant by clients. If not, if you just look up an English dictionary, it means
professional, a customer. 咁其實租客係咪呢？即係
Would tenant be included as well? Is it necessary to give a clear definition? Well, the administration does talk about the target of service, but that's too vague. So perhaps please consider whether you need a definition for clients under Clause 16. Thank you, Mr. Chairman. We will certainly follow this up. All right. So much for interpretation. We've gone through them. We've gone through the terms one by one. Of course, some of them will be studied in greater details. And for some of them, the administration has promised to provide more information to us. So let's carry on. Clause 3. Clause 3, Property Management Services. So this is being defined in Clause 3. The authority may, by regulation, prescribe a service falling within a category of services set out in Schedule 1 as a property management service. And then for Clause 3.2, in the regulation, A, the services must be prescribed with reference to the categories of services set out in Schedule 1, and B, more than one type of service may be prescribed under the category. If I may explain this point, in Schedule 1, in fact, we have made reference to the qualification framework. 7 major categories of services have been listed under the QF. 3.2b says that more than one type of service may be prescribed under this category by the authority. This is because under Clause 7, if a PMC provides one single type of service only, then a license is not needed. Well, it all depends on how the authority is to subclassify the service categories. So if a company provides service for more than one subcategory, then a license is needed. Should we go to Schedule 1 as well? Let's take a look at Schedule 1. As I have said, Schedule 1 makes reference to the 7 categories of services of the QF in relation to property management services. First of all, general management services relating to a property. Second, management of the environment of a property. Third, repair, maintenance, and improvement of a property. Fourth, finance and asset management relating to a property. Fifth, facility management relating to a property. Sixth, human resources management relating to a personnel involved in the management of a property. Seventh, legal services relating to the management of a property. Mr. Yu Kok Him. For the 7 categories in Schedule 1, are you sure that it is comprehensive? Of course, I haven't thought of one that isn't listed. So anything going beyond this scope will not be regarded as property management services, right? Is my understanding correct? Mr. Chen. Thank you, Mr. Yip, for your question. This is a very important part of the exercise. When we approached the 18 districts during the consultation exercise, we did ask the district council's views, and we have also got a committee, and we have got the relevant professionals, engineers, lawyers, etc. They've given us a lot of input as to how we should define property management services. At the end of the day, we believe that the 7 categories can cover the known and existing services. What about security? Off the cuff, I'm thinking of security. What in which category? I think it can come under general management services. Management of the environment of a property can also be incited, or it can also be Category 6, human resources management. It may involve all the categories. Mr. Yip, it seems that it covers all. But what about security? It seems that we can't sort of categorize it. What about security facilities? And there is this question of privacy as well. Well, for facilities, yes, we do include facility management. Ms. Leung has said that under each category there can be subcategories, and then we can accommodate the details. We can find some. For Category 1, general management services. In other words, it could have covered items 2, 3, 4, 5, 6, 7. The administration has said that that isn't their intention. Item 1 is intended as a catch-all. It is only when something doesn't come under items 2 to 7, then it will go under item 1, and they are mutually exclusive. But just now, Mr. Chen talked about security services being subsumed under a number of items. I think security service could not have come under so many different categories. It depends on the subcategories to be drawn up. Ms. Leung, I can confirm the point made by the legal advisor. The purpose of having subcategories is to make sure that when a company provides services in more than one subcategory, then a license will be required. when we draft the subsidiary legislation, we'll try to choose the most appropriate category or subcategory. Sit Ho. Many district councillors and political parties provide legal advice, and we also attend meetings of owners corporations. Now for PMCs, they are companies. I want to clarify this point. Item 7 here, legal services. If we go back to the definition for PMP, it doesn't include those who are providing the service on a voluntary basis, right? I think legal service would be included, but then the subjects of regulation would not be included. Yes, many professional bodies, political parties are providing such service. I'm not sure about professional bodies because they do take out business registrations. I'm not sure, Mr. Chairman. Mr. Chen? Our legislative intent is that we want to regulate PMCs which are providing services. I think for what Ms. Sit Ho has said, that's not about property management service. That's about legal advice. So it is not to be covered. Yes, that's your legislative intent, but then the way that it is drafted may catch it as well. Because on the face of it, you talk about legal services. I can't understand why you say that it doesn't include counseling. It may not actually involve going to court, but then giving legal advice, providing counseling. I hope you will make sure that voluntary service will not be caught. Yes, in the subsidiary legislation, we will make it clear. We will provide clearer definition. Well, for Schedule 1, I think it is quite important because there is this question of providing one single service only. Now, for the 7 categories, each category will be having further subcategories. I think a lot of us are quite concerned as to how you're going to have the classifications, because that would be decisive in whether you need a license or not. So it is important. Just now, Mr. Chen, you have told us that we have to wait for the subsidiary legislation. I have grave reservation because this involves the property management services. Now, for item 1, it appears to me, as the LA has pointed out, that it catches all. Now, we are told that anything not under items 2 to 7 will then come under item 1. Is it clear enough? You have to be clear, because when you provide property management services, then you will be regulated by this piece of legislation. This is most important. Thank you, Chair. Thank you, members, for raising this point. Now we are on Schedule 1, so maybe at the next meeting we should provide detailed information to you as to the scope to be covered by Schedule 1. Yes, Mr. Wu, Deputy Chair? Yes, I want to comment on Schedule 1. Now, they are broad categories. Of course, through subsidiary legislation, there will be subcategories. But then, we have to think about the case of self-management. With a PMC, of course, a lot of things will be covered. If someone would like to stay away from the bill, that is not to be bound by the bill, then they will try to tamper with the model. Now, management of the environment of a property, cleansing, landscaping, I suppose, would come under item 2, because clearly it is a case of management of the environment. So I just wonder if we should sort of be clearer about the categorization. I think the categorization as it stands is too broad. Mr. Yip Kok Kim cited the case of security services. Now, you said that it would come under item 1, general, or item 6, human resources. But of course, for general management services, it will cover everything. And then for human resources management, if you say that security services comes under it, is a bit odd. Experience tells us that usually you have a cleansing contract, a security service contract, a landscaping contract, and they are standalone contracts. Maybe you can try to think along this line, and then it will be easier for the categorization.
聽到嚇。
Mr. Yip Kok Kim. Thank you, Chairman. It's on the same issue. Now, when I look at the schedule, it's mainly to define different property management services. Now, for example, if it's fire services, there are fire services contractors, and they are not PMCs. So they are specialized service providers. Here we see a list of the services. If it's not made very clear, then loopholes may be created. So for these 7 items, we need more specific information, in particular with regard to item 1. Because for property management, there are several things that are the most important. For example, fire services system, security guards, sewage services, etc. All these are very specific. So I hope that more information can be given to us. Yes, we will follow up on this. Mrs. Ho. Well, actually, I want to ask you, Chairman, just now you said that professional institutions may be involved. So when it comes to maintenance, there may be disputes, and OCs may seek the advice of professional institutions, or complaints may even be made. Now, this is my understanding, but Chairman, I'm sure you know more. Can you tell us more? Well, as far as I understand, some professional institutions would provide free service to property owners. And now we have mandatory building inspection schemes. They also provide services. So do they need to get a license as well? Because I don't know what is meant by a single function. I thought it's just one of the services, but now seems it's not like that. So I am worried that if things are not clear, then for the service providers, no matter whether they charge or not, they may be caught by this bill if they don't have a license. This may be very confusing to the professions. I think this is something fundamental that we have to tackle, because we do not want to cause confusions. Well, for legal service, I mentioned it, and I think this is related to that. Now, for this bill, it regulates licensed PMCs, but for owners' organizations, they may seek the help of advisors, because they may fear that the PMCs cheat them. So if an OC asks volunteers to help them, they may be caught by Schedule 1. So do these people have to be licensed? Yes, I share your query. Now, because for one of the exemptions is single service. If that is not clear, then you don't know whether it's single. For example, if he just provides legal advice, would it be regarded as a single service? Or if the advice covers the establishment of an OC or the employment terms of a PMC, the interpretation of the contract terms, etc., whether that would be regarded as a single service. So I think those contained in Schedule, those information contained in Schedule 1 are very important. And members, do you have any other comments? I think we need more detailed information from the government. Mr. James Toh, we just now talked about professional institutions. So if that professional institution does not sign a service contract with an OC, then it does not have to obtain a license? I cannot answer you. Well, that's what I think. Now, for example, if an institution helps an OC and it does it for free, if he is required to obtain a license to do that, there may be a problem. You may think that he has an intention to gain, but the institution does not think so. For example, for district councillor's office, we also have this kind of experience. Because I know law and I have experience, I may provide advice, but of course I will not sign an agreement with an OC. Then I don't need to apply for a license, right? If you draw a line this way, I think it's clearer. Well, for Part 2 of the bill, Clause 6, we have made it very clear. That's under prohibition. 6. No person may, without a PMC license, A, act as a property management company. Now, first it has to act as a property management company. For a professional institution or an NGO, it will not act as a property management company. Or B, claim to be a licensed PMC. I'm sure the institutions won't claim themselves to be licensed PMCs, so they will not breach the law. Well, then I think there are some other problems. Legal advisor. Just now we talked about the definition of PMC. And it means a business entity that carries on the business of providing property management services. Well, it may not be a profit-making one. So an institution does not carry out a business like that. So on a point of whether it's profits-making or not, then I think we really need to seek clarification from the government. For a professional institution, making money or not is the point here. So for property management, there are several professions that are specialized in it. In a professional institution, there may only be a dozen people who would provide free service like this. But anyway, we just want the law to be clearer so that a legislative intent can be achieved. Now, just now, I heard from the government and the legal advisor. The government attaches a lot of importance to prohibition. So if it's not an act prohibited, you can do it. So without a license, if you are doing this prohibited acts, then you will be caught by the law. it will be an offense. So I think we should think clearer. Are there areas that we should follow up on? And the government should also look at its prohibition. Are there still unclear areas which can be further clarified? By doing so, we can refine the bill. Ms. Sitho wants to ask a question. Now, due to the time constraint, I'll give each of you 3 minutes because we will have to end the meeting soon. Ms. Sitho, just now the government official talks about Part 261A. He says that no one may, without a PMC license, act as a property management company. Now, for Schedule 1, well, if you think he has done something that's about property management, but he won't think he's a property management company. So for district councillors' officers, they also have a business license. So of course he would not claim himself to be a PMC, but he is providing this kind of service and is caught by Schedule 1. So would it be regarded as an offense? Because we are just talking about the reality. So we want the bill to be drafted clearer so that it won't catch innocent people. Yes, we will give further thoughts to it. We will collect more information, and then we will see whether the bill is clear enough and whether there's still room for improvement. I agree with Mr. James To's direction. For legal service, the lawyers are doing it. So do you want the lawyers to get a PMC license? Because they are all providing their professional service. There should be no problem. You can't say that, well, a lawyer cannot claim to be a PMC, otherwise it's an offense. So I think that's what Mr. James To means. Now, we are providing district service. I've seen many cases like this. For district councillor's office, they always share their views and give advices to owners. We won't claim ourselves to be a PMC. So the most important thing is to define what a PMC is and to clarify the functions of a PMC. I just want to express my views. Yes, I would like to say something. For a building, if NGOs and professional institutions are providing service to a building, and if it's not for free, then of course there would be an agreement, a written agreement. So I think for the definition, you have to make it clearer. Whether there is a service agreement with the building should be an important factor. District councillor's office would never enter into a service agreement with a building. So I think using service agreement would make things clearer. I want to ask 2 specific questions about Clause 6, prohibition of unlicensed activities. A, no person may, without a PMC license, act as a property management company. As for this concept, how different is it from the concept of providing property management service? Act as a property management company and the provision of property management service. As for legal service, now if the PMC has an in-house lawyer or a compliance manager, now of course the company would have to get a license. But how about the in-house lawyer or the compliance manager, do they need a PMP license? So are they in a managerial or supervisory role? Do they need a PMP license? Do you want to respond now? We can give members a reply in writing concerning the differences between 61A and B. Well, for the legal advisor's question, well, I think the government wants to distinguish the two concepts. But if you draft it this way, I do not know if the distinction is clear enough. So we've talked a lot about interpretation today, and we have also looked at Schedule 1, which we will discuss in greater details later. As for the date of next meeting, I will tell members later, and I hope that the administration can prepare more information so that at the next meeting we can continue to scrutinize the bill. Time's up for today. I think there's no AOB. I declare that the meeting adjourned. Thank you.